Je suis Chad Vickery.
And I'm joined by Daniel Tukaji. He is currently professor of law at Ohio State University. He's an expert on election law and voting rights, specializing in electoral reform issues. He's also the author of Election Law in a Nutshell and co-author of Election Law Cases and Materials. I'm also joined by Brendan Morrissey. He's of counsel at Wiley Rain. Brendan has a litigation-focused practice, assisting clients with trial and appellate matters before courts and federal agencies. He was counsel to Shelby County, Alabama, in its challenge to Section 4 and 5 of the Voting Rights Act. A level playing field is at the heart of genuine democratic elections. IFAS works to support the right of every person to participate in free and fair elections. Our work, therefore, includes promoting equal rights, justice, and inclusion for marginalized or underrepresented groups so that they can participate fully in political life. Voter rights have been especially contentious in the United States, and litigation to protect equal voting rights continues to be a subject of both litigation and debate. The landmark case of Shelby County versus Holder resulted in the Supreme Court striking down Section 4B of the Voting Rights Act of 1965 and effectively removing the coverage formula, determining which jurisdictions require federal preclearance before enacting changes to their voting laws. In an attempt to share insights on the American electoral system here at the U.S. Election Program, this panel will discuss the implications of Shelby in the broader context of voting rights and political inclusion. Today, Brendan will speak about the lead up to the filing of the action, including prior litigation in the 2006 reauthorization of the Voting Rights Act. He will also discuss recent changes in several states, including Texas, North Carolina, Ohio, and Wisconsin, and how and whether preclearance would have affected the implementation of these laws. After Brendan speaks, Dan will provide some more context to the Voting Rights Act and the preclearance process. The context preceding the case, including what the Voting Rights Act preclearance was and wasn't doing. He will also discuss what has happened since 2013, including new state laws and practices and litigation challenges that under the Constitution and Section 2 of the Voting Rights Act. So with that, I'll hand it over to Brendan.
Thanks, Chad, for inviting me to participate in this panel today. I wanted to start out by saying that, I'm here as to give my perspective as someone who participated in the actual litigation of the case and to provide that unique perspective here for you all to hear. Basically, the backdrop of all of this is that, here in the United States, we have kind of dual regulation of elections. We have the states with primary responsibility, and then we have the U.S. federal Constitution, which provides certain fundamental guarantees covering, amongst other things, voting rights. And so with that situation, you have basically states with primary power, except that they can't do anything that would violate the United States Constitution. Then Congress also has the ability to, quote, enforce the fundamental rights in the United States Constitution. And that's where the Voting Rights Act comes in. So in 1965, Congress made the determination that certain additional measures needed to be taken to enforce those fundamental rights. And so there were a bunch of different provisions of the VRA, but one of which was Section 5. And so what Section 5 did was kind of unique in comparison to some of the other things that were going on in the Voting Rights Act. It set up, for lack of a better term, a prior restraint. Basically said states can't do anything, change their election laws in any way, until they get approval from the United States Attorney General to make that change, which was, it's hard to overstate how much of a shift that was from kind of the baseline system that we have here. It kind of flips it on its head, in fact. But that was only in certain areas of the country, and as Chad mentioned, those were designated in Section 4B of the Voting Rights Act. So that set out the formula, who has to actually go through that process. Everybody else was just kind of under the baseline system. So that's where Section 5 comes in. It was controversial from the outset, and what's actually interesting is that Congress put a provision right in the act that allowed jurisdictions to bring constitutional challenges to this. So That's something that you see sometimes in election laws where there's some question about the constitutionality of it, and this was not an exception to that. And in fact, the state of South Carolina and several other states took Congress up on that offer and challenged it immediately. The Supreme Court upheld Section 5 and other provisions of the Voting Rights Act at that time, finding that given the circumstances that existed in the early 1960s leading up to this, it was that was a justified use of the enforcement power. It was challenged again on a couple of other occasions, Section 5 was, and again upheld both times. The thing about Section 5 also is that it was limited in time period. So you had a situation where initially it was only supposed to be in place for 5 years and then reevaluated, and in fact it was. So in 1970, they reauthorized it. In 1975, they reauthorized it. 1982, and then it was set to expire again in 2007. So by the time 2005 came around, they were thinking about this again. It was still in place, basically unchanged in terms of the coverage formula. And so Congress took up the task again at that point. The relevant committees of both houses of Congress held hearings on whether this was continued to be justified. They took in a lot of evidence, some of it, in my view, better than other evidence, but they held a lot of hearings. They compiled what's been described throughout the litigation as a 15,000-page record that they thought justified this particular action, which nobody can say that they didn't work hard at this. So that was basically the reauthorization process. What was kind of important at the time, though, was that there were serious concerns about going forward kind of on the same basis as had formed the justification for the original act. So going forward on the same coverage formula. Is history enough to justify this type of thing? Or do we need to look at more modern circumstances? What's really going on the ground today? Ultimately, not to impugn the academy, but they got, I think, some bad advice about updating the coverage formula. Some folks came in and testified and said, basically, history is enough, plus current circumstances in those jurisdictions. You don't need to look at everybody and say, well, where should this be going forward? What you should do is look at, is it still justified in the areas of the country where you've had this all along? I think ultimately that's what doomed the act when we get to the litigation. So, but there was also testimony about things happening in other areas of the country, things happening in areas of the country that were covered by the Voting Rights Act that did not justify continued coverage. And so the testimony was kind of a mixed bag on that. But from the perspective of a litigator and someone who brought the case to that we're here to talk about today, in our view at least, and in the view of many covered jurisdictions, there wasn't a lot of evidence of constitutional violations of the United States Constitution to justify continued use of this particular provision. So at the time, there was that was something that was debated, and a couple of senators, in fact, thought, there was a constitutional problem with it. They ended up voting for it in any event and kind of kicked the debate to the courts. So that's where the first challenge to that after 2006 was a case called Northwest Austin. They saw two things. One was to get out of coverage, so they asked for what's called a bailout. They asked for the court to declare that they were basically on good behavior for 10 years, and that would put them on a kind of a parole system, for lack of a better term. They'd be out, but they'd be subject to continued monitoring. And then they also asked for Section 5 of the Voting Rights Act to be declared unconstitutional. That went up to the Supreme Court in 2008-2009 time period, and then 2009 the Supreme Court ruled on the bailout question, allowed them to bail out, and kind of ducked the constitutional question, which raised it again for someone to bring a challenge. So that's primarily, that's background to tell you how basically we got where I came in. We'd been doing some work for the Project on Fair Representation, which is a group of folks who are interested in fairness in elections and things of that nature for some time. Some of it had led to litigation, others had not, but we'd been doing a bunch of memos for them, and by the time the Northwest Austin decision came out, we thought we had a good shot of actually getting the actual litigation. So thought about discussing with people the the possibility of bringing on a jurisdiction to actually challenge the act. So we did that. We had written a couple of amicus briefs. Nobody paid any attention to those in the Supreme Court. But up to that point, that was basically where it was. So we ended up speaking with some folks in Shelby County, Alabama, which was a jurisdiction that was covered under the act by virtue of the state of Alabama was covered, and Shelby County was a county in the state, so by virtue of that, it was a covered jurisdiction. Shelby County itself had been kind of a model of voting rights, to be honest with you, for a decent time. There had been some cities and towns within the county that had their own issues of complying with Section 5, but Shelby County itself was pretty good. And so we signed them on. They decided to file a complaint, and so we did that. One of the things that we decided to do from the outset, though, was to bring two claims, which ended up being important, I think. The first was a challenge to Section 4B itself, which was the coverage formula. The second was to bring a challenge to Section 5. So because of some things that the court had said in Northwest Austin about coverage being outdated, we thought that breaking it down in that way would really crystallize the issues for the courts when they were addressing that issue. And that's ultimately the way that we proceeded, and ultimately the way that the court ruled. It ruled on the Section 4B issue, finding that the coverage formula was outdated and did not respond to current conditions, did not rule on the Section 5 issue. So basically the baseline that we have today is if Congress creates a new coverage formula, Section 5 will be back in place. But as of right now, it's not, because there's no valid coverage formula.
Let me just start by thanking IFES for bringing us all here today, for inviting me, and to thank all of you for being here. It is a great honor to be among such a group of people from around the world who care about democracy as much as we do. The foundation of democracy, any democracy, is the right to vote. This right has long been recognized as fundamental by our Supreme Court, even though our Constitution does not explicitly protect voting rights as such. Our court, since the 19th century, however, has said that the right to vote is fundamental because it is preservative of all rights. None of our interests, be they in education, employment, health care, whatever it might be, are safe unless we are able to vote and participate as equals in democracy. I say this by way of introduction because although this principle has long been proclaimed in the United States, it has not always been respected. And even today in the United States, there are practices which diminish, dilute, or impair voting rights by some of our citizens. So let me, in my brief remarks, start by providing some context, both on the United States' unusual electoral system and on history, before moving to the question of what the preclearance provisions of the Voting Rights Act were and weren't doing at the time that the Shelby County case, which Brendan discussed, was decided last year. So first, some context on the U.S. election system. We are very unusual in two major respects here in the United States. The first is the profound decentralization of our system. Elections are not run at the national level in the United States. We have no entity with general responsibility for managing elections here, as is the case in most other countries. Rather, elections are run, for the most part, under the laws of the 50 states, and they are actually administered at the local level, literally by thousands of counties and municipalities, each of which has authority for actually running the day-to-day operations of our voting system at the local level. So we have not just one voting system, nor even 50 in the United States, but literally thousands. The other distinctive characteristic, some would say pathology, of the U.S. election system is partisanship. What I mean by that is that in most states, the chief election official is someone who is either elected or appointed by their party and runs for office as the candidate for their party, or is appointed by someone who is elected as a candidate of their party. That is to say, the chief election official in most states is, in that sense, a partisan. This creates an inherent conflict of interest between the chief election official's responsibility to serve the interests of all voters, to create a level playing field, and that official's interest in serving his or her party and advancing through the ranks of his or her party. It is a problem that is, by the way, well recognized among other democratic countries, which is why the chief election authority in most countries enjoys some degree of insulation from partisan politics. This, however, is unfortunately a lesson that we in the United States have yet to learn. Next, let me give a little bit of historical context. For most of this country's history, racial minorities, most notably African Americans, have been systematically denied the vote in much of this country. That was still the reality 50 years ago in 1965 when the Voting Rights Act was adopted. And there is no question, as Brendan pointed out, that things have changed considerably in the intervening period. At the time of the Voting Rights Act, blacks were systematically kept from voting or even registering throughout the southern states, which are still, for the most part, the states that were covered, at least as of 2013, when the court decided the Shelby County case. What was the Voting Rights Act doing, and what wasn't it doing? There has been, in recent years, a lot of discussion in the United States of vote suppression, practices that allegedly make it more difficult for eligible citizens, especially racial minorities and poor people, to vote. Voter ID, which you'll be hearing about in the next hour's panel, is the most prominent subject of criticism by those who complain of vote suppression. But there are other practices such as registration rules, limits on absentee voting and early voting that have also been criticized as instances of vote suppression. The perception is that the preclearance provisions of the Voting Rights Act were an effective tool against these vote suppression practices. The reality, however, is that they were quite rarely used to stop those practices. Where the preclearance provisions of the Voting Rights Act were most often used was with respect to what we call vote dilution at the local level. So, for example, new lines are drawn for city council elections. In the United States, state and local legislative bodies generally have responsibility not only for running elections, but for drawing the district lines from which people are elected to office. And allegations are sometimes made that those lines dilute the strength of minority votes. So the pre-clearance provisions that Brendan discussed were mostly used, and in my view, were most effective with respect to these local practices, at-large elections, redistricting, and so on. That's what was really lost by the Supreme Court's decision in Shelby County. And I'm not especially interested in relitigating that decision here, right? I disagree with the court's decision. I tend to think that the places that had problems 50 years ago are still the places with the worst problems of race discrimination today. That said, these issues that I've discussed, and I presume we'll discuss further in this panel, making it more difficult to vote and have one's vote counted, these are really national issues. And at some point, I would like to see the United States Congress take action to establish a baseline of uniform rules for registration, identification, and early voting, so that the many people who move across state lines in the United States know what the rules will be for voting when they move. As it stands now, if you move across state lines, you may face entirely different rules regarding registration, identification, when you can vote, and so on. We have, in my opinion, a lot to learn from the rest of the world when it comes to the way we run elections, including the protection of voting rights in the United States.
Right, thanks. I think adding to that list of federal issues ought to be the interaction that people have with voting. What's the machine or the type of voting that takes place so that it's consistent? Because some machines are more accurate than others. Also, a huge issue in the United States is absentee voting. And a lot of litigation now comes up about absentee voting, and that too is different for each jurisdiction. But I think now we could turn to what happened after Shelby County and what has happened since then. Brendan?
Yeah, sure. So, basically there was a call almost immediately to update the coverage formula, which was what was struck down in the Supreme Court's decision in Shelby County. It took a little bit for a draft bill to come out, but eventually one did. And so, I was asked to kind of think a little bit about, what are the options for updating it if there was a desire to do so, and kind of what's the situation if they don't do that. I think I'll start with that latter question first, which is Section 5 was, as I mentioned at the beginning, only one provision of the Voting Rights Act. Section 2 applies nationwide and actually does address a lot of the dilutive principles and practices that Professor Takagi was speaking about. In fact, it's mainly used for those purposes. The trouble is with, the unique feature of Section 5 was that it stopped things in its tracks before a practice took place, whereas Section 2 comes after the fact. And so that was, I think, actually what was lost, as opposed to the ability to target these practices generally. So there is still a judicial mechanism for targeting these practices in Section 2 of the Voting Rights Act. There's also Section 3 of the Voting Rights Act, which is what's called bail-in, which creates a situation where if a jurisdiction is found to have violated the United States Constitution in terms of voting rights, then that jurisdiction can be brought into the type of pre-clearance process that Section 5 used to have kind of as a default rule in certain areas of the country. So that is directly responsive to ongoing constitutional violations and is can respond to current conditions in jurisdictions. And then of course there's the Constitution itself. There's a cause of action to bring an action against a state, a local jurisdiction based on a violation of folks' constitutional rights. And so all of these things still exist. The one thing that does not exist is the prior restraint, the thing that stopped the practices before they could start. And so to my mind, what's going to need to happen is folks are going to have to think long and hard about, is that prior restraint something that has to come back, or are the claims and causes of action that currently exist on the books sufficient to deal with the types of voting discrimination that everybody agrees still exist today? Okay, because there are things that go on across the country, and nobody will deny it, I think, that violate the United States Constitution. And so that's the question in my mind, is whether that's going to be necessary. To my mind, the draft bill that was released, I don't think appropriately addressed that particular concern. I think it was more of a move to do something quickly as opposed to trying to strike the right balance. And so in that respect, there was going to be a modification of that Section 3 bail-in that would have responded to not constitutional violations, but other types of violations. In my mind, in reading the Supreme Court's decision, and this is just as an outside observer, I wasn't an outside observer, but reading the Supreme Court's decision, in which I have no particular insight any more than anyone else, I don't think that type of bail-in would be constitutionally sufficient. And then I think a coverage formula of the type that is not going to respond to constitutional violations, but is going to respond to some other types of violations or statutory violations is probably not going to pass muster either. So those are things that they're going to have to think about. I'm not in charge of any of these things. So I'm just kind of observing this from the outside. But to my mind, if Congress was going to go that route, it would probably be subject to challenge again, and that would have a reasonable chance of succeeding. So those are my views on kind of the landscape of where Section 5 stands after the Shelby County decision.
Great, and I don't know if we have any discussions about specific states, what's happened, if maybe,
Sure.
Yes.
Sure. Let me actually talk about two things. First, the legislative picture at the federal level, which Brendan addressed, and secondly, what's gone on in the courts. The bottom line in terms of what our Congress is likely to do is nothing. We have enormous party polarization and stalemate. There has been a bill proposed with mostly Democratic support, which, as Brendan mentioned, would create a new coverage formula and would require disclosure of the impact of voting changes. There are some features of this bill I really like, others about which I'm less enthusiastic. But the bottom line is that in this very divided Congress, it's not going anywhere, nor is any voting rights bill going to go anywhere. As I mentioned earlier, I'd love to see a bill that imposed greater standards at the federal level over all these issues and might resolve some of the contentious debates that we've had in recent years, really since 2000 over voting. But that's not likely to happen anytime soon. So, as is frequently the case, where these controversies wind up being ultimately resolved is in the courts. We've seen a significant increase in litigation over voting rules in recent years, really since the 2000 election, which first brought these matters into court. And some of the restrictions that I mentioned earlier, voter identification, limits on where and how you can register to vote, restrictions on absentee and early voting, rules regarding the counting of provisional ballots, voting technology, all of these practices have been challenged in court. In fact, in my state alone, every single one of the practices that I just mentioned has been challenged, right? This is to be expected when you have partisan legislative bodies making the rules for elections, when you have partisan elected officials, for the most part, running elections. Questions about this conflict of interest that I mentioned earlier are inevitably going to arise. And in our system, the institution that is most insulated from partisan politics is the court. So in my view, it's quite appropriate that the courts be the arbiters of these disputes regarding the fairness of election rules and whether or not there really is a level playing field, as Chad earlier mentioned. And we've seen litigation very recently over election rules. 4 cases are especially notable. A case in my state, Ohio, regarding restrictions on early voting, as well as same-day registration. A case in North Carolina involving a law enacted right after Shelby County that imposed a variety of restrictions on voting, including on early voting, same-day registration, imposing a voter ID requirement. And then lawsuits in 2 more states, Wisconsin and Texas, both involving voter identification rules. Right? The lower courts have not come out the same way on all these cases. As we lawyers say, they're still percolating through the lower court system. It remains to be seen exactly what the Supreme Court will do. The Supreme Court actually issued or got involved in 3 of these cases just this past year, but did not issue an opinion on the merits in any of those cases. I tend to think that its involvement had more to do with its concerns about court orders issued very close to the election than it did about what exactly the court thinks on the merits of these cases. But at some point, I suspect these issues are likely to come back before the United States Supreme Court, possibly very soon.
Great. Brendan, if you have anything on some of the states in particular.
Well, yeah, sure. Just in particularly in the context of Section 5, since that's what we're here to talk about, I think it's important to point out that, of the states that that were just mentioned, North Carolina was partially covered by the Voting Rights Act. There were roughly 40 counties, I believe. 40 of the 100 counties in North Carolina were covered. Yeah. The state of Ohio was not, although covered by Section 2 of the Voting Rights Act like the rest of the country. And then the state of Wisconsin is also not. So in terms of, particularly in light of the fact that the Supreme Court ruled on the coverage formula, I think this is actually a very good illustration of some of the issues with the coverage formula as it existed at the time when at the time of reauthorization in 2006 and at the time that it was struck down. We're seeing a lot of these hot button fundamental voting rights cases coming out of areas of the country like Ohio and like Wisconsin and I think anybody could agree that they're just as likely to come out of those areas of the country as they are anywhere else. We could debate whether coverage should properly have covered a lot of the original areas today as well, but I think everybody would agree, the state of Ohio in the last 3 to 5 years has been as likely a place as anywhere else to have a big decision come out on fundamental voting rights, and it's pertained to early voting primarily in the last couple of elections, but same-day registration, as you mentioned. There's some other things as well. And then Wisconsin has been in the news as well for voter ID. So in terms of the coverage formula, I think that's actually instructive. And what we've seen before, during, and after kind of the time frame of when the Shelby County decision came out from the Supreme Court is that we're not seeing this isolated problem in certain areas of the country. Yeah. We're seeing a lot of problems come out of other areas as well.
what really triggered these changes was the fact, if we're going to be very honest about this, that in 2010, Republicans did very well in elections across the country, so that in 2011 we had a lot of Republican governors and Republican-dominated state legislatures, right? And in this country, racial minorities, particularly African Americans and Latinos, vote overwhelmingly Democratic. So the allegation and the perception, at least among many Democrats, is that Republican legislatures have adopted these rules in order to make it more difficult for Democratic-leaning people to vote, right? That's at least the perception. But it was really the turnover of state legislatures in 2010 that triggered this wave of voting restrictions rather than Shelby County. And it is certainly a national issue, voting rights, which is why I'd in the end like to see a national Voting Rights Act, a Voting Rights Act for this century. I prefer that to the geographically limited coverage formula that we had under the old Voting Rights Act.
I think in this conversation, I think it's interesting to know that the coverage formula from Section 4 determined which states that the Civil Rights Act really applied to in regards to preclearance of election law. And then Section 5 was what allowed the federal government to look at those laws. But there's still Section 2 in the Civil Rights Act that allows the federal government to prosecute individual cases when they find something that runs counter to the Constitution or the Voting Rights Act. I don't know if either one of you, to put you on the spot, if you think about how turning to Section 2, if it's still an effective tool, if yes or no. And I think the reason why it's interesting, because that's more of the way in which you all would prosecute something, would be an individual action of an individual person or party, which is still available under Section 2.
Yeah, since Brendan responded to this earlier, why don't I take the first crack at that question, and it's a very important one. Section 2 of the Voting Rights Act prohibits election practices that result in the denial or abridgment of the vote on account of race. It's mostly been used in vote dilution cases in the past. For example, in cases challenging the way that legislative districts are drawn on the ground that they weaken the collective voting strength of a racial minority group. So the important difference between a Section 2 case and the old regime under Section 5, as Brendan pointed out, is that plaintiffs have the burden in Section 2, right? They have the burden of showing a discriminatory result. And these cases, as I'm sure he knows as well, can be really, really expensive to litigate for both sides, right? There are differences in the legal standard as well, but I don't know that we need to get into those here to understand what was really lost by the Shelby County decision. So what was lost, I think, is the ability to check voting practices at the local level that are never going to be the subject of the lawsuit. Some local school board adopts new legislative districts that are at least alleged to weaken minority votes, right? The Justice Department, under our old system, had responsibility for reviewing all those changes and either granting preclearance, denying preclearance, or as it did in many cases, requesting more information, right? And so I think that the preclearance requirement of Section 5 was a pretty effective check on minority vote dilution in these places. It did impose some burdens on state and local government. I wouldn't deny that. But they were modest burdens, certainly in comparison to the burden of actually marshaling the expert evidence, necessary to bring or to defend against a voting rights lawsuit. So I do think that something important was lost by the elimination, effectively, of preclearance. Brendan and I may disagree on that point, but I do think we agree that that's, for better or for worse, the main work that the Section 5 preclearance requirement was doing before Shelby County.
Right, and I think what's interesting is the burden of proof almost always is on the plaintiff in an election case. So I think in most of the countries that we work around the world, the person filing the complaint has to prove the claim by the standard of evidence. And as we've all known, how does that plaintiff get access to the evidence they need to prove their case? And in an election situation, the timeline can be so short that it can be really difficult to gather that evidence. And so there's a interesting election issue here in regards to how a plaintiff can actually prove their case and move it to the next level. And as a litigator, Brendan, I wonder, I mean, how long did it take to bring the Shelby County litigation? We didn't have 48 hours.
Yeah, we did not have 48 hours. This was it was a facial challenge to the act, though, and so, you know, this was not a challenge to a particular practice in Shelby County, you know, so, which is what you would find if someone were challenging a new voting restriction or something like that. So this was brought by the county against the Attorney General, and so, you know, the goal was to declare Section 4B or Section 5 unconstitutional. We filed the complaint in 2010, April of 2010, and it was decided in June of last year, 2013. So that took us 3 years, and you know, it was expensive. This was not, but Section 2 cases are actually even more expensive. Yeah. They're very fact intensive, and Professor Takagi is absolutely right about that. But you know, as Chad also pointed out, that's the norm in our legal system and many legal systems, is that the plaintiff has to prove their case. And so when we were looking at Section 5, not only was it a prior restraint on the change in practice, but it was also, it put the burden of proof on the jurisdiction to prove it wasn't discriminatory, which was a huge change. And so that's, I would argue, as difficult, if not more difficult, than a plaintiff having to prove their case kind of after the fact. So, you know, proving that you're not discriminating is difficult. You know, you can do it with statistics, you can do it with testimony from legislators, you can do it by kind of taking a results-oriented approach, but in the end, if you don't prove your case, you can't change your law. And actually, I represented the state of Florida in a preclearance case that had to do with early voting and some other changes a couple of years ago, and that burden of proof was a huge issue in trying to convince the court that the change should be pre-cleared. It was a cutback in early voting hours, but you know, early voting days rather, but the same number of hours ended up being provided. And so the question was, okay, well, does this discriminate or does it not discriminate? And so there are a lot of different ways of proving that. And as the jurisdiction, having to prove a negative was very difficult. And you know, some would say it was intentionally set up that way, right? But I think that would have been a particular instance in which addressing it after the fact would actually have shed more light, and we would have probably ended up in a better place than trying to address that before the thing went into effect.
Thank you. I think we want to get to a point where we can have questions from the audience, and we'll turn to that now. But I would just like to say that I think this discussion's interesting because, as we discussed, the voting rights that are enshrined in our Constitution are being defined by the courts. I think Bush v. Gore from 2000 pushed a lot of these issues to the forefront. Mm-hmm. It's interesting to see where we've come. Are we better or are we worse? I don't know. One thing to consider is election administrators. A lot of the machines and a lot of the reform that took place, or a lot of the machines that were purchased, voting machines, are now 14 years old. Yeah. So what's going to happen, and you will see this when you go out and look at when you go and do observation, you're going to see old machines, different machines. It's very interesting. But it is unique, I think, that the courts are trying to be the referee when there's all these different jurisdictions, which is a different role than I think what you all are used to. But with that, I want to thank the panel for their remarks, and I want to open up the floor to questions.
Actually, we do not know as to what is the language of the Section 5 and Section 4, what is the substance therein, what changes are introduced into the law by way of Section 5 and Section 4, what evils have been removed, which existed previous to the legislation of Section 4 and 5. So if you kindly tell us as to what is the language and what is the substance, what is the motive of Section 4 and 5?
Great. I'll try to repeat the question. And for the future questions, if you could just identify who you are and then so we all know who's asking the question, we'd appreciate it. The question is, what's the specific language of Sections 4 and 5? And how has litigation changed that?
Yeah, sure. So Section 4 created the formula, and that's all. There's a bunch of other stuff in Section 4 as well that pertain to literacy tests and things like that, which are kind of not germane to this. But Section 4B basically created a formula whereby the jurisdictions that were singled out would be subject to additional restraints. So Section 4 said any jurisdiction in which voter turnout was below a certain threshold in particular elections, 1964, 68, and then eventually 1972, would fall within the formula. It's generally the way that it worked. And so what that did was you would have an agency of the United States government go and take a look at the statistics and say, these particular jurisdictions fall within what Congress said the formula would cover. Then for those jurisdictions, there's additional regulation of their local elections, whereas normally there would not be otherwise. And so in Section 5 was one of the things that happens by virtue of falling within that formula, that coverage under Section 4. There are other ones as well. Having observers, so election observers deployed to local jurisdictions, that was another thing. And there's a couple of others. But basically, the consequences come later. But Section 4 was targeted just at who is going to be subject to those additional consequences. Section 5 is actually the provision that created the restraint on changes in election procedures and said, you local jurisdictions, if you're covered, you can't change anything until we say so. And set out the criteria for determining whether the change could be made or not.
And I think Section 4, and maybe we can discuss it a little bit further, is that it was based on historical practice, like who historically had, and I don't know if Professor wants to, but I think that who historically had discriminated. Yeah. And then once you determine you met that equation, then the other sections applied to you. And that's what was kicked out by this case.
And so just to very briefly sum up, Section 5 required certain covered states to obtain advanced permission from the federal government before changing their voting rules. Section 4 prescribed which states had to go through this process. And originally, when the Voting Rights Act was enacted in 1965, it was exclusively southern states. Those were the states with the worst problems when it came to the disenfranchisement of African Americans, states like Mississippi, Alabama, South Carolina, Georgia. They had the lowest rates of African American registration and participation, and so the formula was designed to capture the states with the worst problems of voting discrimination in 1965.
Great. Yes.
Thank you. Arif Budiman from Indonesia. You say that election in the U.S. is decentralized, means that every state have their own regulations. Yeah. So if some voters live in Virginia, at the voting day, they must travel to California. My question is, first, do they allow to use their right to vote at the voting day going to the polling station? And if they are allowed, what kind of ballot paper do they have to punch. Is it Virginia a ballot paper or California a ballot paper? Thank you.
Great. Thank you for the question. The question is, if someone travels to another state during election day, can they vote at the other state? And if so, what kind of a provisional ballot would they use or whatnot?
So if someone is going to take your example on vacation or a business trip from Virginia to California, they're still residents of the state of Virginia. They are citizens of that state under our Constitution, and therefore would have to vote a Virginia ballot, the state in which they reside, which is going to be very different from the ballot that someone in California would see. So if you're going to be away from your jurisdiction on election day, what you would typically do if you want to vote is cast an absentee ballot before the election. Every state allows people to request an absentee ballot that is typically sent through the mail and returned through the mail. So that is how you would vote if you were someone from Virginia who was going on a trip to California and was therefore going to be away from your home on election day.
And I want to add to that that in a lot of the litigation now, if there are recounts or challenges to an election in the United States, many times the question of absentee ballots and if they're legitimate voters and whatnot, this is where a lot of the litigation happens, is looking at these absentee ballots, as you can imagine. Any other? Yes.
My name is Abdoulaye Babale. I come from Cameroon. I am the electoral board member. In my country, we organized democratic elections since 1960. But up till recent, we are facing general contestation of elections. Candidates who didn't get the rate of voters they were expecting would like the whole process to be nullified. So we have a lot of protests at the Supreme Court of our country. Government and the electoral body develop important investment. We have a biometric system. We try to decentralize our system, both for local elections, Senate elections, House of Representatives elections, and presidential elections. Yeah. But the regulation is uniform because we have a united country, not a federal country, not a federal, the federal level, state level, no. Our country is a united one. Yeah. But my question is this: how does the American system to build the confidence of voters on one side and different political parties and their candidates on the other side? Because you describe many, many, many differences between states of the American Federation. Despite these differences, the general impression we have from outside and when we came, we watch at the TV, is that the American people have confidence in their electoral system. How does this system do to build such a huge and permanent confidence? Thank you.
Right, that's a very important, the question is, how is there such trust in the US system when it's so diversified? How do the courts and the election administration participate together to build trust, both of the candidates and the voters? I hope I've got that right. And I'll turn this over to the panel, but very quickly, I mean, the largest way to increase trust is to win by a large margin. I think also the courts, our system, the legal system also is diversified.
Yeah.
And so the courts play a huge role. But with that, maybe we can turn it over, I don't know, Brendan, would you like to go first?
Yeah, I mean, honestly, it's a long history of doing the right thing. We've got a couple hundred years of history here of, you know, folks respecting the rule of law and knowing who the final authority is on whatever the particular question is at hand, and respecting that and abiding by it. You don't have, you know, if a court decision comes down after an election, Bush v. Gore, you might have a lot of complaints about the results, but you don't have a lot of people, you don't have anybody defying it, for instance, okay? And so I think that's the most important aspect of, you know, instilling confidence in our elections is, even if you disagree with the result, the state of mind here is that people approach these questions in good faith, and that things work themselves out in the end. And so you don't presume, we don't presume bad faith on people's parts in this country generally when it comes to these things.
Yeah.
And so if you see anomalies, you first assume it's a mistake, only later deal with the consequences if it's not. And so I think that's generally the baseline view that we have. How did we develop that? It's an excellent question, but you know, all I can say is that we have a very long history of presuming good faith and abiding by the decisions of the final decision makers on whatever that particular question is at hand.
Let me emphasize, there has not always been historically such great confidence in the integrity of the U.S. election system. If you go back 100 years, boy, we had a lot of problems in our system. Ballot stuffing, bribery of voters, practices like this, these were not uncommon around that area, late 19th, early 20th century. And sometimes later in certain places, most notoriously Chicago. Right? Even if you just go back a little over a decade, right, there was actually a survey, a cross-national survey that was conducted shortly after the 2000 election, which found that among democratic countries, the level of confidence among U.S. voters in the integrity of the previous election was extremely low. Right? I mean, you know, on par with, I don't want to single out any country, but countries that are generally not considered to be democratic at all. Now, I do think that confidence in our election system has rebounded considerably since then. It's partly history. Let me suggest it is also, I think, at least in part, the fact that there's at least some division of authority, which Chad referred to. Yes, we have partisan state officials, but this decentralization, right, while it has disadvantages, has an advantage as well. It makes it more difficult for any one party to capture elections, say, in all of our 88 counties in my state of Ohio. We also have divided authority in the sense that courts, state courts and federal courts, are looking over the shoulders of legislatures and election officials. To my view, this is a very salutary thing, that we have courts that are acting as a sort of backstop, stopping partisan manipulation, at least where it goes too far.
Great. Thank you very much for that. This is going to be the time to conclude the panel. Thank you very much for your attention. I think this is a unique panel in that it really does illustrate how diverse our jurisdictions are and how we've tried to, this country has tried to deal with some of these difficult questions in regards to the diversification of our electoral processes. So it was very good. Thank you very much to the panel for your time.